The Kowalski family says the ruling sends a message.
Parents have rights, and they make the decision for their children.
That was Maya Kowalski's father after their huge verdict win in Florida while their daughter was in hospital. And it kind of is suggesting that parents do have rights and make medical decisions for their children. Well, after reading this appeal decision, I'm not quite sure that that is true. Is this appeal decision a devastating blow for the Kowalski family and a win for mandatory reporters? Hello, Legal Mind friends. This is Karen Cole. Let's get started. Mandatory reporters are those who suspect a child's best interests are not being met and are mandated to report it to Child Protection Services, and we will talk more about that part of the law in just a bit. For those of you who don't know about this civil trial case, before I share the summary of the decision of the appeal court, let's go back in time as this news clip gives us a great summary.
Tonight, a verdict in the case at the center of the Netflix documentary, Take Care of Maya. It is a trial we've been following closely since mid-September. And this is Nightside. I'm Dave Wagner.
And I'm Jenny Dean in for Carolina. Just hours ago, the jury found Johns Hopkins All Children's Hospital in St. Petersburg liable on 7 claims and 2 punitive charges. 10 Tampa Bay's Hannah Deneen was in Venice tonight and spoke to Maya just moments after she walked out of the courthouse.
Dave, Jenny, the jury has awarded the Kowalski family more than $260 million in this medical malpractice lawsuit against All Children's Hospital. Just hours ago, reacting to their victory outside the courthouse.
I mean, for the first time, I feel like I got justice.
After 8 weeks of testimony and evidence, All Children's Hospital is found liable on 7 claims, including false imprisonment, medical negligence, and wrongful death. The Kowalski family says the ruling sends a message.
Parents have rights, and they make the decision for their children.
The case has garnered national attention as the subject of a Netflix documentary. It depicts Maya Kowalski's battle with a rare disease and her family's experience at All Children's Hospital. Her mother, Beata Kowalski, was accused of Munchausen by proxy, medical child abuse, and doctor shopping. Maya, just 10 years old at the time, was separated from her family for 3 months. The family argues this prompted her mother to take her own life.
To me, it was about the answer, knowing that my mom was right. I want people to know that she wasn't harming me at all.
But All Children's Hospital says the verdict sets a dangerous precedent.
If there is a situation that evolves here in which every caregiver, every reporter who thinks there's a problem suddenly gets sued if they report the wrong thing, or if they make a good faith error, we're going to have a lot of hurt children in this country. We may have some dead ones.
Attorneys for the hospital say they also plan to prepare an aggressive appeal. We have a full breakdown of the compensation the Kowalski family was awarded and the full statement from All Children's Hospital up on 10tampabay.com. In Venice, Hannah Deneen, 10 Tampa Bay.
So now I want to tell you about a little story that happened over here across the pond. We had a similar concern, and a civil lawsuit was brought against a mandatory reporter. In the case that I'm going to tell you about, the medical professional thought the father had caused injuries to his daughter, a 10-year-old girl. While treating the child in hospital, the father was not allowed to see the child. The mother was allowed to be with the child while she was in hospital, and the doctor, after further examination of the child, conceded the child suffered from a rare skin disease and was discharged from the hospital. The father should no longer be implicated to being the cause of what caused her symptoms that the doctor had the concerns about and the reason he put the safeguarding measures in place. As you can imagine, this caused the father great distress, and he sued the hospital for misdiagnosing the child, causing him great distress, including taking photos of the child without the parents' consent. On appeal, the European Court of Human Rights decided, let me read that part of the decision for you. Court noted that the authorities, both medical and social, had duties to protect children and could not be held liable every time genuine and reasonably held concerns about the safety of children vis-a-vis members of their family were proved retrospectively to have been misguided. So those are the key words, and to have a genuine and reasonable concern, even if they found out later on it wasn't the case. So, they had a right to initiate a safety precaution. And the hospital did file an aggressive appeal against the Kowalskis' win. The Florida Appeal Court made a very similar decision to the European Court, that little story I told you about. The Florida Appeal Court 2nd District decided, and I'm summarizing, if a mandatory reporter has a reasonable concern, as they are mandated to report it, and to not do so would be a felony. The act of reporting in good faith is not liable to a civil compensation or punitive damages. So the appellate court thought the trial judge got that part of the law wrong on reporting and awarding civil and punitive damages. So basically they're saying you cannot punish them if they were doing the reporting in good faith. Now I want to play a clip from the civil hearing, and we're going to hear from one of the attorneys on behalf of the hospital explain the concerns that the doctors had. Then I want you, chat, to answer, was it a reasonable concern of medical abuse? If you had heard what you're about to hear, would you agree that this was a case for mandatory reporting and that it was done in good faith? So let's have a listen.
You hear a lot about ketamine in this trial. Ketamine is indeed an old drug, and it's a drug that is approved by the FDA for use as an anesthetic. It is not approved for use in children, nor is it approved for use in high doses as treatment for CRPS or chronic pain. That's one of the issues here. It's not just ketamine itself, but how it was used and the quantity in which it was used. Because ketamine is an anesthetic, it is an hallucinogen, it can create dependency, it can cause depression of vital signs. If not properly monitored, it can cause serious injury, life-endangering consequences. Mrs. Kowalski on this day was challenging the staff to give her daughter a dose of 1,500 milligrams of ketamine. That is a big dose. That dose you're going to hear is several times, many times, the maximum dose that policies at all children's approve. You're going to hear experts tell you that is many times any kind of safe dose. And you're going to hear in the next few weeks is that Maya Kowalski had been given thousands, tens of thousands of milligrams of ketamine over the preceding 9 months. Her doctor, Dr. Hannah, had given her the day before admission 1,250 milligrams of ketamine. And at that time, he's going to testify to you that he told the mother he was no longer comfortable giving that much ketamine, that it was too much for him to give in his outpatient clinic. And he actually sent her to All Children's. You're going to hear that over the 9 months preceding this, that he had given her a gradually increasing doses of ketamine, 12, 15, over 20 milligrams per kilogram per hour, which is dozens of times the safe and effective dose that was approved by the hospital and that is talked about by the FDA, and that it's never been written up in the literature. You'll hear Dr. Hannah say, either by deposition or by admission on that witness stand, that this was at or near the highest per capita dosage he had ever given any patient. It wasn't working. So what had happened was that he had maxed out with this ketamine dosage. He had sent her to All Children's, and Mrs. Kowalski, despite what he had told her, despite what had happened over the last 9 months, was demanding even more. Child being given levels of medication that they had never heard of before, that the literature did not support, that the literature didn't even mention. And so they put her in a safe environment, they attempted to get her stabilized, they called the correct consultations, and they tried to investigate what was going on. We will suggest to you, the evidence will suggest, and the experts will say, that that was a perfectly reasonable thing to do. There's no conspiracy here. It was an effort to safeguard this child and to see that she got appropriate therapy going forward, whatever that happened to be.
Now, you're probably wondering if the hospital's decision was within the law to report to child protection. How could the Kowalskis win damages in civil court? That was the concern of the appeal court. They decided the trial judge erred in his interpretation of the law, and there should have been a directed verdict. The trial judge's decision to allow a jury to decide damages, both civil and punitive, against a mandatory reporter were errors. Now, remember the news clip I played of Mr. Kowalski, Maya's father, saying parents have rights. They make the decisions for their children. With that in mind, let's watch another clip of the child protection doctor who testified at the civil hearing. And after you hear this, answer the question, how could the hospital be liable when a dependency court made the decision? There was medical abuse and made an order that was in the best interests of Maya to wean her off the high doses of medication and put boundaries to limit the risk of Mrs. Kowalski, Maya's mother, interfering with that course of treatment for Maya. In these clips you're about to see of the civil hearing, you are going to hear the child protection doctor. It gets heated, but see if you can catch the attorney for the Kowalskis trying to argue that this doctor made the decision, not the dependency court.
Before, or let's say, right at the start of this, in the first part of October, you had a call with Dr. Kirkpatrick, did you not?
I did.
And Dr. Kirkpatrick explained to you that he had been treating Maya Kowalski for CRPS, correct?
He did.
And he told you that statistically speaking, CRPS is often mistaken for conversion or Munchausen by proxy, did he not?
I don't really remember exactly what his words were. I took a few notes from the conversation that I had with him, and I know that there was some general discussion along those lines.
And yet you did not put anything in your report about Dr. Kirkpatrick, did you?
Yes, I believe there's a whole section about his medical records.
Yeah, except for the fact that you did not tell anyone in that report that he had warned you off of going after the Kowalskis.
It's completely irrelevant for a child protection team medical evaluation, because that's the whole point of the evaluation and gathering all the records. The problem in these cases is that the treating physicians have not done that. And so the fact that he, who sent her to Mexico for the ketamine coma, told me not to investigate child abuse, it was completely irrelevant to me, because my job was to investigate child abuse. So if I had come away from my job saying, I was supposed to do this, but this doctor told me not to, so I'm not doing it, and there's no evidence of anything here, I would not have been doing my job even remotely near a standard of care.
Do you not understand the importance of putting both sides of the story in your report?
The both sides of the story is the responsibility of the various people who are going to present it to the court. My job as the medical director for the child protection team is to do what I need to do to assist the investigators and the detectives and the attorneys that are involved in the case as to whether there is evidence to support a diagnosis of whatever type of child abuse is being assessed. So it's not my responsibility to lay out some whole long argument about what it might be otherwise if I have extensive evidence to support that it's a type of child abuse.
So you are the ultimate decider of medical issues which you have minimal or no training in.
I have extensive training.
Yes, but you're not.
That's a proffer. You can answer, Dr. Smith.
I have extensive training in evaluating child abuse and neglect. Medical child abuse is a child abuse pediatric diagnosis. There is a parallel track in psychiatry where there's a thing called factitious disorder imposed on another, which is assessing the perpetrator or the caretaker in that scenario. But I don't need a psychiatric degree to assess medical child abuse. I'm very well trained to evaluate medical child abuse based on my child abuse pediatrics experience and board certification.
Well, there's not a single child psychologist or psychiatrist that agreed with you. You do realize that, don't you?
No, I don't.
Well, name a child psychologist or psychiatrist that examined Maya Kowalski who agrees with you.
Well, that wasn't their job to write in the report whether there's medical child abuse, so that specific thing documented by, for example, Dr. Cabot or Dr. Katzenstein, I don't know, honestly. I'd have to look back to see if they ever documented that as one of their diagnoses, but that's not their job. My job is to assess that, and if I present adequate evidence to the court can act on that. So, you know, the court has every ability to pull all these people in, including Dr. Kirkpatrick, including Dr. Hanna. I think they testified in the dependency action. And if the judge decides that there's serious question about whether I'm right, then, you know, the court makes that decision based on the evidence that they receive. That's not my job to litigate the whole thing and put out all of the potential possibilities in the case and say, I'm the child abuse pediatrician, but I don't really know if there was child abuse here, because in this case, there clearly, in my opinion, was child abuse here.
Yeah.
I can assess whether the person that, you know, made thousands of dollars was reliable or not. And I didn't find those people to be particularly reliable in terms of their diagnosis, even though I certainly included their information in my report.
Dr. Hanna, an anesthesiologist with over 25 years of experience in treating CRPS, you didn't put his confirmation, or excuse me, he did a diagnosis of CRPS in your report either, did you?
I believe in the history, I made reference to that. Yeah, I'm pretty sure I did say that he, you know, made that diagnosis. But this is a doctor who was giving a child, a 10-year-old child who was on the small side, 1,000 milligrams of ketamine, anywhere between 8 and 32 milligrams of Versed, doses of Zofran, 1,750 milligrams typically of magnesium, all at the same time in an outpatient setting with no documentation of vital signs, and there was indication in the records that appeared to me to suggest that the family member was the person monitoring the pulse oximeter. So that person, to me, is not particularly reliable in terms of whether this child needed the treatment that she was getting, whether he made an accurate diagnosis or not. So I put his information in my report. Yes, I discounted his diagnosis.
And of course you discounted Dr. Cantu's confirmation of CRPS.
Well, I never got any records from Dr. Cantu, so I couldn't really address that whole situation other than from the WordPress blog. This person put a 9-year-old child in a ketamine coma for days. It took her probably about a week to just be able to be discharged from the hospital after that.
So
I didn't find him reliable from what I saw.
All right, so if I'm understanding you, the fact that 3 different treating anesthesiologists specializing in CRPS, 2 different neurologists specializing in the treating of CRPS, you know more. Fair?
I don't know more. As I said, I looked at their information, and based on what was done with this particular child, I did not find their opinion to be reliable.
And who elected you to be the judge of whether all of these board-certified physicians were reliable?
Nobody. I presented it to a real judge who made a determination.
Well, isn't it true, ma'am, that you are not a medical investigator? You are, in fact, a medical prosecutor?
That's absolute nonsense.
Because an investigator would include both sides of the story and let the judge decide, right?
No. The Child Protection Team medical director will assess whether there's medical evidence to support a diagnosis of child abuse, and then the dependency attorney will present that to the judge. And the other side gets attorneys also. There were 5 in this case. And they present all the information, and then the judge tries to decide, whose information is more reliable.
Here, under oath, are you telling us, are you an investigator or are you a prosecutor
I am
of
neither.
the information?
I'm a medical doctor who is an expert in child abuse pediatrics.
Mr. Anderson,
I got
any
it.
very wide latitude.
I'm done.
You're finished?
Yep.
Okay. Mr. Hunter, anything further in proffer?
Very briefly, Ron. When you spoke with Dr. Kirkpatrick and he warned you off, did he tell you that he had last seen this child 10 months before the conversation?
I honestly don't recall if I already knew that. I might have already known that.
And when you wrote your report, you had the Tampa General Hospital records, the Lurie Children's Hospital records, the All Children's records predating October of 2016, correct?
Correct.
All those hospitalizations with all those specialists that saw this child, did you see any of them suggest that CRPS was the diagnosis?
No, and multiple were experts in complex regional pain syndrome.
Thank you.
Is the proffer complete?
Yes, sir.
Yes.
So what we heard in the proffer, and that is a testimony under oath to preserve the evidence for an appeal outside the jury. So the jury was not present for that. After that exchange, would you agree the dependency court made the decision? Maya's parents did participate in the dependency hearing. We heard with 5 attorneys. So parents do have rights. But as to medical treatment, the dependency court made the medical treatment decision that was in the best interest of Maya. And over here in the UK, another similar decision was made with a baby's parents who wanted to take their child to Italy for treatment. And the High Court ruled the treatment in Italy would not be in the best interest of the child. And the evidence from the medical specialists was accepted over the parents. The parents wanted to appeal, and they did, but their appeal was rejected. So parents do not get to make medical decisions when specialist medical professionals have convinced a dependency court, and in this case, High Court, that it is not in the best interests of the child. I have heard some chatter on the internet that the appeal court in Florida basically just reiterated the hospital's arguments, taking their side unfairly, given the High Court's decision. Over here, across the pond, it appears to be a very similar position. Now let me give you a summary of the appeals court in Florida's decision. I was playing around with AI voice to read the summary. So here, let's have a listen, as I was rather impressed.
Here is a quick summary and explanation of its main points. Court ruling summary. Legal action, meaning judgment in favor of the Kowalskis is reversed. The lower court's decision, where the Kowalskis won, has been overturned by the higher appellate court, reversed and remanded with instructions. The ruling is overturned, and the case is sent back to the lower court for a new trial or further proceedings under specific guidelines. Only the IIED claim brought on behalf of Maya and the remaining false imprisonment, battery, and medical negligence claims may be retried. The new trial is limited only to these specific claims. IIED stands for intentional infliction of emotional distress. LaRose, J., concurs. Judge LaRose agrees with the outcome and the reasoning of the main opinion. Smith, J., concurs specially. Judge Smith agrees with the outcome but has a different legal reason for doing so. They usually write a separate concurring opinion to explain why. In essence, the Kowalskis lost their original victory, but they have the chance to win a new trial on a limited set of claims.
Now I want to play a short clip from Court TV as they had a robust discussion. The clip I am playing is from the perspective of the hospital, and Court TV did have a written statement from Maya's attorney, so I suggest you check that out as they discuss the claim going forward that Maya can file. So, before you watch that, let me tell you, out of the 3 panel judges who concurred, there was a separate opinion by one of the 3 appeal judges who wrote their own appeal. In addition to agreeing with the other 2 appellant judges, that opinion basically said although the hospital was in charge of overseeing and making sure that the hospital followed the dependency court orders, the claims against the social worker, Mrs. Beata, fell under intentional infliction of emotional distress in regards to Beatty's behavior and the nurses, given their special relationship. I take this to mean that they were there for Maya's daily needs and they knew her vulnerability. So back to the opinion. Though some of the actions taken by Beatty and the nurses and others related to the hospital are entitled to immunity under Chapter 39, it is not an absolute to have that protection. For example, you cannot lie to a patient, and battery, false imprisonment, and medical malpractice claims cannot be used to meet the legal threshold for Maya's IIED claim. Though the jury should be told about some of the information related to Maya's shelter and dependency court orders to give the jury a full picture of the circumstances at that time. Now let me play a segment from Court TV as it appears the hospital is holding strong on their position.
Journalist Andrea Dunlop, who's been following the case closely. She's also the co-host and creator of Nobody Should Believe Me podcast. And we wanted to speak to someone from the hospital. They referred us to you. Andrea, so let me start here. What's your take and your view on the Kowalskis, on Maya?
And the reality is, Maya is alive because of these interventions. And so this appellate decision is a massive win, not only for mandatory reporters, it is a massive vindication of the doctors who did the right thing in this case. And it is a massive win for those of us who believe that children deserve to be safe in their homes.
So would you agree they believe they saved Maya's life? And I have left a link in the top right of this video on the screen. Click to watch their discussion. What you need to know is a parent's consent is required for medical intervention unless the intervention is for life-saving treatment or ordered by the court. And the story I told you in the beginning about the little girl where the doctor had taken photos of her, this is what the court decided. The intervention of taking photos was not critical in that case. And the court noted that the mother most likely would have agreed. However, if a parent does not agree, the hospital could have applied to the court for an order. So the European Court found no justification to this being done to a 9-year-old child who was at the time alone in the hospital. And I think the court awarded them something like $4,000 around there, so it wasn't very much. In the Maya Kowalski case, we found out a similar situation happened and photos were taken of Maya without her consent, without her parents' consent. So I think, the case going forward, they'll have to, make arguments on each side. Was it critical? Was there a safety risk? She was going to be leaving for court and her uncle was going to pick her up. So risk management wanted some photos of before and after of Maya. Maya saying that she didn't want the photos to be taken. Parents are saying they needed their consent. The hospital is saying that, Maya didn't get upset when the photos were taken and they were necessary because they were told to do it by the hospital. So, Yeah, that will be an interesting argument if the Kowalskis do decide to continue to go forward. And before I go, let me just play this little bit of a heated exchange between the social worker and the attorney for the Kowalskis, and then let me know your opinion.
Did you attempt to contact the parents? That's the question. First question is, did you attempt to contact the parents?
I did not. But I did contact DCF.
Did you make any further attempts, or at least document it in the record, that you tried to get a hold of the parents?
I didn't attempt to call the parents.
And did you comply with number 3? The actual contact with the parent's legal guardian, advising the parent's legal guardian of consent and treatment authorized by DCF.
I did contact DCF, who was the legal guardian at the time for the child, yes.
No. There was a guardian ad litem appointed, was there not?
The guardian ad litem doesn't have consent.
Did you document anywhere in the file, if the jury was to look, that you tried to contact the GAL?
I wouldn't have contacted the GAL. The GAL is not the guardian.
And in the records, would you agree, there is no analysis of these photos from a medical standpoint?
I don't know that.
So you knew going in that you were, what reason was it then?
Dr. Danielson asked us to document her skin condition.
And you would do that no matter whether it was allowed or not?
Objection argumented.
True.
Overruled. She can answer that.
So we did this, or I did this because this was asked of us by Dr. Danielson, and it had a good reason for it. If it was not a good reason, I certainly would have been discussing it with the medical team.
Dr. Danielson is not with DCF, is she?
No, she's not.
Charlotte Laporte, did you attempt to get authorization from Charlotte Laporte?
I did get authorization, talked with Charlotte Laporte that day.
You say you did.
Mm-hmm.
So if she testified in this courtroom that you did not, would she be incorrect?
Objection argumented.
Overruled.
I don't know. I was talking to her that day, and they were doing their own pictures in Sarasota.
So, go ahead.
And I explained to her that we were doing the photos here at the hospital.
Again, I just need to know, is she says in court that you did not seek any permission from her, is she wrong?
I can't. I don't know what she said and what she didn't say.
The reason
is that you're communicating to Ms. Condon with respect to the photographs when she got back?
The pictures are done, and that I'm locking the camera in my office over the weekend.
Do you use the same camera to take the before pictures and the after pictures?
Yes.
Okay.
By leaving a comment, you may help someone else that will read your comment. And of course, I love to read all comments as they are valued, and together we can be more informed. And this information may help you or someone you know. In the meantime, on this channel, you'll find a variety of playlists to suit every curiosity about the justice system. And we provide you with a visual to information and the process. Going through a legal worry is devastating, and the Who Knew and Why Me playlists are designed to help you or someone you know. So please like this video if you like this kind of content. Hit the subscribe button and the notification bell if you want to be notified when I'm going live or upload another video. I'm Karen Cole from Legal Minded Friends. Information is power, meaning if you know something, you can make decisions that are right for you.